Hi, y'all, and welcome to the live stream. We've been talking about the Vallow Daybell case, and there are two tragic heroes in the middle of this case, this really horrible case where Vallow Daybell is accused of killing her own 7-year-old son and 16-year-old daughter and conspiring to kill the wife of the man she would marry 2 weeks after the death of Tammy Daybell. Tammy Daybell was, according to the prosecution, killed. Lori Daybell, Lori Vallow, married Chad Daybell 2 weeks after 49-year-old Tammy Daybell suddenly died. But in the middle of this, there are two people who have been all along doing the right thing, trying desperately to find their grandson. I'll show you a picture. This is Kay and Larry Woodcock. They are the grandparents of JJ Vallow, the 7-year-old who was found dead in the backyard of Chad Daybell. And these grandparents, Kay and Larry, have been from the beginning instrumental in finding JJ's body and finding what happened to JJ. They have done everything differently from Lori Vallow Daybell. For example, they offered a $20,000 reward to find JJ. This was when Lori Vallow Daybell was giving them no information, giving the public, giving the police no information about where their child was, their grandchild was. And then they also asked for a welfare check when JJ was missing. They said, okay, JJ is missing. Police, would you please go and look and see if you can find him, because we haven't been allowed to talk to him. We can't get hold of him. We haven't heard from him, and we're worried. And the police went, and it was the beginning of everything, because the police went and Lori Vallow Daybell told them, oh yes, he is with my friend in Arizona. And when they talked to the friend ultimately told them, no, he's not with me, hasn't been with me. And that began the process of finding JJ and Tylee, who also was missing. Now, what we're going to be talking about today is the fact that there has been a motion, a movement, I guess you would call it, a request by the defense to keep Kay and Larry Woodcock out of the trial. And I'm going to go through what the judge ruled. I'll give you a spoiler alert. Kay can be in the trial, Larry cannot, but we'll talk about, there's a caveat to that, and I'll explain all of that. One of the things I really try to do with this channel is I actually want to explain things so that you understand them. That is actually my goal, is that you can understand some of the huge cases, the really interesting cases, but you don't have to have a law degree. So a really helpful comment for me would be at the end, if you would say, did you understand or not understand? Yes, of course. My favorite comment of all time is something that says, love the show. I'm subscribing. We'll be back for more. Of course, that's my favorite. But I also really appreciate comments that tell me whether or not I'm hitting the mark. Are you able to understand when I explain this? So I have some new diagrams to show you and to try to talk you through what exactly the court rules so you can understand what he said about Kay and Larry Woodcock and what the ruling is going to be. Now, a quick update on where we are in the case, at least the last update I saw, we are still one juror short. And at this point, I'll do an update just to make sure nothing more has happened. Nope, we're still one juror short. And what they're looking for is 42 jurors. They've been selecting the jury all week, and those 42 jurors will ultimately be winnowed down by strikes from both sides. The defense will get some, the prosecution will get some, and they can just use them for any reason and say, we don't want that juror, we don't want that juror. With the exception we've been over on other days, it can't be gender or race-based, but they can, other than that, anybody they don't want on the jury, they can strike. We're going to ultimately get down to 12 jurors and 6 alternates. I got a great question from somebody. I said, well, what about those alternates? Do they sit through the trial? They do. They sit through the trial. In many courts, not the Murdoch court, but in many courts, they don't even tell the jurors which ones of them are alternates. You can probably guess why. The reason is because the goal is for them to be able to fill in if somebody comes out. And if someone knows they're an alternate, maybe they don't pay quite as close attention. Maybe they don't really maybe they don't really pay attention to those things. Goodness. Sorry. Just a minute. I'm trying to get back to comments and so forth. Okay. So maybe they don't pay quite as close of attention. Maybe they aren't really playing along. And so maybe they don't really end up being able to be the same sort of juror, even if they have to fill in. So that's one of the reasons why a lot of times courts don't tell them. Kay Vallow Woodcock herself has confirmed that Larry will be in the courtroom with her. Fascinating. That's coming from Mama Pink. Thank you for that. I'm going to go through and explain to you what the court ruled, and then we'll see what happened as far as what any ruling was, as far as what has been decided since then. And you'll understand how he might possibly be there, how that might happen. So we're going to get started on that. Let's take a look directly at what the court ruled, and I'll take you into the actual court order. You know, that's small. I think I'm going to try sharing my screen with you. Yeah, that's definitely bigger. So let me head over to that so I can walk you through it. So, okay, here is the court's order about Kay and Larry Woodcock. And I'll take you through exactly why the court was even ruling on this. So the court said, look, the general rule is, or a rule that I can invoke is, potential witnesses can't sit through the trial. Because why? They might hear the testimony of other people, and they might not be able to, they might change their testimony, or it might even just be affected. Even if they didn't do it directly, it might be affected by what they'd heard. And so the state said, look, there are some people, Judge, that you need to allow in because they are related to the victims in this case, and there's a constitutional right to that. So let's go through what are the general relationships, and then I'll show you graphs too that will take this a lot deeper. Now, Lori Vallow Daybell legally adopted JJ. In fact, I'll go ahead and take you to that. So Lori, here's what happened. Lori Vallow and Charles Vallow adopted JJ. Now, how did all this happen? Kay was the natural grandmother of JJ. And as you can see, then JJ was adopted by Kay's brother, Charles Vallow. Charles married Lori. Lori also adopted JJ. So the bond of grandmother was broken by the adoption. That's what Lori's team claimed. And that's the relationship they were talking about. At the same time, now Ethel K. Let me get my. There. Okay. So Ethel K. Woodcock is the biological sister of Charles. I told you about that. Lori Vallow Daybell is the biological mother of Tylee. Now, Tylee is another victim, the 16-year-old victim. Summer Shiflet is the biological sister of Lori Vallow Daybell. Colby Ryan is the biological half-brother of Tylee and adoptive half-brother of JJ. And then there's no relationship between defendant Vallow Daybell and Tammy Daybell. Now, why is that relevant? Because there was some speculation that maybe the Vallow family could come into the trial. There's no sign that they necessarily want to, but if they wanted to, that was going to be considered. So here is the law. Under Rule 615 in the Idaho Rule of Evidence, at a party's request, the court may order witnesses excluded so that they cannot hear other witnesses' testimony, or the court may do so on its own. And the court raised it here on its own. But you can't exclude a crime victim under the Idaho Constitution, and as that's defined. So now let's go to what the Idaho Constitution says. It says that the rights of crime victims, as defined by statute, include the right to be present at all criminal justice proceedings. So victims can be present at a trial. They can't be excluded just because they're also going to testify. But what's exactly who actually is a victim? who actually fits that. So according to Idaho Code Section 195306, a victim is someone who suffers direct or threatened harm. I'm going to shorten it. And that applies to immediate families of homicide victims. Now, why? You can understand that, really, because homicide victims can't show up for themselves. If the person was assaulted and lived, they can come to court. But a homicide victim, by definition, can't. So someone can come for that person. The immediate family can come. And it says the court may designate a representative from the immediate family to exercise these rights on behalf of a deceased, incapacitated, or minor victim. Now, I will tell you, and then the court in a case define what an immediate family member is, because it's not, that could go pretty far, right? For one thing, I would have assumed that a grandmother and grandfather would be included, but that's not the case under this Idaho case law. The immediate family member is a parent, mother-in-law, father-in-law, husband, wife, sister, brother, brother-in-law, sister-in-law, son-in-law, daughter-in-law, or a son or daughter. So that's, to me, was somewhat surprising, because I would have expected it to be something where there would be a grandmother and grandfather, and that would be immediate family. And I was sort of surprised that brother-in-law, sister-in-law, son-in-law, daughter-in-law were included. But that's how it's going to be defined under the Idaho law. So the court said, okay, and this is throughout, the court seems to have been upset with the state for failing to produce things. That's one of the reasons he took the death penalty off the table for Vallow Daybell. And again, he says, I'm supposed to be notified about the people you contend are victims, and I still haven't gotten the form that you're supposed to fill out. He just throws that in, and that just kind of shows he still remains kind of upset with the state. So he says, to be clear, and this is something to be explained, that the family members of crime victims are always permitted to attend the criminal proceedings. That means they can attend, including the trials. For example, let's say there's a hearing. There's a hearing that says that, where they're going to discuss evidence that may come in, or there's some kind of hearing that people are, it's not sealed. It's a hearing where everybody can ordinarily come in from the public. Well, future witnesses, he's saying, could come and could attend that. What they can't attend is where other witnesses are testifying. And I would assume that would also apply where they're going to summarize any kind of testimony from a potential witness. So this is about being present at trial during testimony, and is saying, look, and the judge says, look, I have to be careful, because if the victim is not legally qualified as a victim and they actually then want to testify, I may have to prohibit that. I may have to say, no, you can't, because you sat through the testimony and I'm not going to let you testify. So the court said, okay, I can't find that Kay Woodcock, the grandmother, qualifies as a victim, because grandparents aren't counted under the law. That's not in the immediate family member as set out by the court. But he says, and here's where we'll go back to our graph. He says, look, but a victim, a fair victim, would be Charles Vallow. Charles Vallow was the father of JJ. Now I put the X there so you can see Kay is not allowed to come in as a grandmother of JJ. So the X going down, she can't come in as grandmother. She also can't come in as aunt of JJ. That's also not going to be an acceptable relationship where she's allowed to come in. But she is allowed to come because she's the sister of Charles Vallow, and he was a victim. He was a victim in the sense that he was the father of JJ. But you say to yourself, wait, Charles Vallow was dead. Charles Vallow was not actually alive at the time JJ was killed. In fact, Vallow Daybell is being charged in Arizona with participating in the death of Charles Vallow. So Lori is accused of killing not just JJ, but also Charles, who was at the time her husband, and she, according to the prosecution in Arizona, also killed him. But the court said, look, Charles would have had rights. And here it's interesting, and I hope I don't get too technical on this. I'm going to try not to, but it's a super interesting argument. Shows my nerdy legal side. Here's what he's saying. The court has the authority to designate a representative from the immediate family to exercise these rights on behalf of a deceased, incapacitated, or minor victim. Remember that phrasing? So I read that to say that he has the authority to designate a representative from the immediate family of JJ, because JJ was the victim. And earlier in that very statute, it talks about the homicide victim. But the way the court read that was, no, I can designate a representative from the immediate family if the person in the immediate family is deceased. I can then extend it out further. If somebody in the immediate family can't attend because they're deceased, I can take it to the next level then. Actually, ironically, the defense, the Woodcocks themselves also interpreted it the way I did. And you could see, for example, this is their motion, they said JJ Vallow had no immediate family, and they asked the court to designate the Woodcocks as representatives of JJ. But that's not what the court's doing. The court is designating is designating Kay Woodcock as a representative of Charles Vallow, who is the now deceased father of JJ. So if you followed all that, it's actually, I really think, after having read it several times, I think the court's probably right. I think that's exactly what was meant by the statute. So what that means is Kay can come in because her brother would have been a victim because his son was killed, his adopted son, JJ. So Kay will come in as the sister. Will come in as the sister representing Charles Vallow, who cannot be there because he himself is deceased. That's how she gets in. So the next person the court looked at, and I'll just go ahead and add the stream, is Summer Shiflet. Now, she doesn't meet the legal definition of immediate family member, is what the court said, because she's the biological sister of Tylee Ryan's parent. Summer Shiflet is Lori Vallow Daybell's sister. So she's the biological sister of Lori, but just as Kay Woodcock couldn't come in as aunt, neither can Summer Shiflet come in as aunt of Tylee Ryan. But he says, Lori neither Joe Ryan, Tylee's father, who also is deceased, perhaps mysteriously, but since he was cremated, there's no real understanding that he died in 2018, rather suddenly, but of a heart attack, as it was believed at the time. So Lori, and there's no evidence that I know of that Lori did anything, just it's another person who died in the immediate vicinity of Lori's family grouping. So, but Lori is also unable to represent Tylee because she's accused of actually murdering Tylee. So the court appointed Summer Shiflet not as the aunt of Tylee, but as the nearest relative, immediate family relative of Lori, and to stand in as victim for Tylee Ryan. So it's, in other words, and we'll go back to the exact wording so you can see exactly what the court ordered. So the court said, look, Summer Shiflet is just an aunt, so I can't let her in that way. She doesn't fit in there. But she is also the sister of Lori, and I'm going to designate her as a representative of the family of Tylee, since both of Tylee's parents are unable to be represented as victims here because one of them's dead and the other one is on trial for murdering Tylee. So that's how she comes in. Now, the clearest, easiest person to get in was Colby. Colby Ryan is Lori's son. She had a total of 5 marriages, counting Chad Daybell. One of the marriages resulted in Colby Ryan. I think he may have been adopted by Joe. That may be why he has the last name Ryan, or I may have the last name wrong. I'm not sure which. Then Lori also had Tylee Ryan, half sister to Colby, and then she adopted JJ. The court said, look, this is an easy one because these are siblings in this case, half siblings or half adoptive siblings, but that's easy. Colby Ryan can come in. He is immediate family to Tylee and JJ. I don't really have to worry about that. That makes my life really easy. And so that was his ruling there. Then the final person he evaluated was Larry Woodcock. And Larry Woodcock, he said, didn't meet any of the legal definitions. There was no way he could appoint him. He wasn't in any way related directly to any of the people. He simply married Kay. This is particularly harsh. Kay and Larry raised JJ. They kept him for the first almost year of his life. They were actively involved in his life until Lori refused to allow them to see him. For many years, they were heavily involved with him as true grandparents. But what the court said was, I can't find any way under the statute that you can be shoehorned in as immediate family. You just don't fit. And so I can't do it. This is what he said. But look, you can observe all the proceedings. If there's not testimony, that's fine. And they have been coming. They've been coming to the hearings and showing up and participating. They've talked to the police. They've done all of the things that good, loving grandparents would do. He's saying, and he also gave this sort of hint to the state. He said, once you actually testify and you're no longer needed, then as soon as you're released, you can watch the rest of the trial. And he said this, the state has the means to order its testifying witnesses however it sees fit. Should the state wish to call Larry Woodcock early in its case in chief, that is entirely the prerogative of the state. In other words, what the court is saying is, if you want to put him up as your first witness, he doesn't miss anybody. He doesn't miss any of the testimony because he's done and he can sit through it. Now, there are occasions when a witness may be called back as a rebuttal and isn't released as a witness. You may remember in the Murdaugh trial, there was somebody who came back in rebuttal and testified a second time. That's probably not going to be the case with Larry. Once he testifies, it's probably over and done. But it's not necessarily that easy to put somebody first. It all depends on what the things they're going to testify about are. Because a lot of times, and I'll go ahead and take that out for now, because you have to build the foundation and lay the foundation for all the documents that you're going to ask the person about. Now, it may be that Larry Woodcock is going to be able to be there from the beginning. Maybe he, first of all, doesn't have, maybe they decide not to call him to testify, or maybe they call him first and there's nothing needed. I mean, after all, what he's going to say is, she wouldn't let me talk to my grandson. I became very worried. I went to the police. I asked for a welfare check. And from that point on, it was clear nobody really knew other than maybe Lori, who wouldn't tell where my grandson was. And so I spent a lot of time trying to figure out where he was. So at that point, the court is saying, I don't know what you're going to do, state, but you have a way around this. If what you really want to do is figure out how to get him in, you have a way around it if you want to put him first. If what you want to do is bring him in right away, get it over with, you can get it over and done right after he testifies. If everybody will release him, he's not needed for rebuttal, then he's going to be able to sit through the trial. But I can't do anything about the statute. He just doesn't fit. I can't make that any different. So can Larry hear opening arguments? That's a really good question. I would argue no. I would argue no. I understand that it's just related to the testimony, but typically what the prosecution is going to say is, you're going to hear this, you're going to hear that, and talk about here's what's going to happen. I would just say, as a matter of being clear, that I would, and safe, if I was a judge, I would not want them there, but I don't actually have an answer on that. What I have always done and what I've always seen done is that the all the witnesses do not sit through opening, but maybe, that I'm not saying that that's always the way it is in every court. That's just how I've experienced it in the past. So Nancy Landis is asking a really good question. She's saying, okay, and she's saying this confusion is only because Lori's defense team thinks having these people in the courtroom has negative pressures to Lori. That's a really good question. Now, why is the defense team trying to keep Larry and Kay out of the courtroom? Why? And I think the answer has to do not just with how it makes Lori feel, which I would imagine it would make her feel extremely uncomfortable, but I would think it's really because of the impact they could have on the jury, because they are, in fact, victims. They will be emotional about all of this testimony, as anybody would be, and certainly as grandparents would be. All of this is going to be something that's going to emotionally connect with the jury. And I think that's what the defense wants to avoid. I think that's why they care about that, more than just how it makes Lori feel, although I don't doubt that that's part of it. I think they also are worried about how the jury will feel and what the jury will think when they see Kay and Larry sitting there day after day, just standing in for the victims. And when they're reminded over and over again that there are real people who were affected. This isn't just a body. This is a real person. And there were people who loved JJ. And that's, I think, got to be a big portion of why they don't want Kay and Larry in there. They're very personable, very likable, sweet people. And I have no question that they would be very interested, that they would be very impactful on the jury. So tomorrow night, we have an absolutely great show for you. I am super excited about that. I'm trying to read the questions while talking. It never works. Let me see. Let me read these real quickly. What if the defense reserves the right to call Larry but never call him? The defense has no reason to call him. I just can't see that would ever be something where they would make an argument that they plan to call him or might call him. We'll see. But I guess that's possible. It could happen. I guess that could happen. Tom Crossan, well, I hope you are not murdering anyone. So I don't want to represent you in your murder trial. Please do not murder anyone, but thank you for the super chat. I do appreciate that. So we have an absolutely great show tomorrow. We are going to be running through the entire case. And I'm talking about the little rabbit trails, the extra stuff, so you can get the full lay of the land before the trial starts. We're going to have Lori Hallis with us. She's a criminal defense lawyer, now retired, and she's writing a book on this particular case. She's been writing a book since a while back in the case. We're going to be talking to her about all of the ins and outs, the details we may or may not know, the questions we have, and getting the full lay of the land so we are ready to go when the trial gets started. I'm super excited about that. I think it's going to be absolutely great. So don't forget to subscribe, because you want to get with the notifications, because you're going to want to be reminded that tomorrow night at 7 o'clock, we're going to be doing that show, and it's going to be really great. So be sure to make a comment. Did you follow this? Did you understand it? Let me know. And I should have said this at the beginning, but no fair commenting. If you only listen to the last minute or the first minute and saying, oh, I don't understand, you have to listen to the whole video. But if you don't understand, it honestly helps me to know, okay, I'm not quite getting it right. And that will help me. So that's a fair comment. I won't be mad. I won't be hurt. I honestly appreciate real feedback. Of course, I also love subscribers and people who like watching the content and like the videos. So I want to play once again as our outro, the fantastic outro that was done for us by Michelle Lisa. So I'm going to add that to the stream as we're going off and say, once again, thank you to Michelle Lisa. If you haven't been to her YouTube channel, you have to find the right Michelle Lisa. She has one video. It's my outro. I could not be more flattered or more tickled. I am so grateful to her. It's a fantastic video. And so that'll be our outro. I'll see you at 7 o'clock.